Got it.
Thank you.
You betcha. Thank you. Appreciate it. All right. So anyway, what I'm going to show y'all are the markup copies. This is what the Broker Lord Committee and TREC looks at when they're considering the changes, and they're color coded. And the way it works is any print in black stayed the same. Anything in red will have a line through it that was either removed from the contract completely or moved someplace else. Anything in blue and underlines in addition. All right, first one's no big deal. The Consumer Protection Notice. We have to have it posted in the office. It has to be on a link on your website. They added 2 notices that have nothing to do with us. They have to do with the inspectors. It just lets the public know that inspectors do have errors in emissions insurance, and they may try to limit their liability through their contract. Fine. Then, the addendum for property subject to mandatory membership in a homeowners association. I'm not sure it's a change so much as they combine 2 paragraphs. C, which has always been fees, and D, which is deposit for reserve. So again, anything in black stayed the same. Anything in red is being removed or moved. Anything in blue they added. So you know exactly what they did at a glance. So what they did is they took fees and deposits, put them into 1 paragraph. Fees and deposits for reserves. Except as provided by paragraphs A and D, which is referring to the fee for the resale certificate. Buyer shall pay any and all association fees, deposits, and reserves, and other charge associated with the transfer of the property not to exceed blank dollars, and the seller will pay any excess. So we're going to take them all and lump them together. The homeowner association charges $100 just to switch the name over from the seller to the buyer. But the homeowner association also charges a 0.5% transfer fee. There's a developer out there that charges a 1% of the sales price foundation fee. They're going to take all these fees together, lump them together, and put them here. Now, there's no one place to get those numbers, are there? I mean, you check with the homeowner association on this. If you know there's a developer, you check with that. You talk to the title company, talk to other agents who've done that, but you take your best guess and you lump all those numbers together and put them there. Questions on that? All right. So the 1 to 4 family contract. All right. First of all, the promulgation date up here, 11/10/2020. That's the date TREC actually vote on the forms. They become effective immediately. But like I said a minute ago, we don't normally see them on the street for a few weeks. It takes TREC a while to, they have to update their meetings, put those out for publication. They have to get the formatted done and then get it. So I'm watching TREC's website every day. Matter of fact, hang on, let me check that real quick. Let me see if by chance any of them have popped in today. I doubt it, but we'll see. Go to TREC's website here. Contracts. Nope, not yet. Okay. So just keep watching it and do that. But what happens is you probably, if you've been through this before, what happens is there's a period of time where you're allowed to use either the old version or the new version. TREC will publish a date. They haven't done it yet, but they'll publish a date that once you hit that date, you can only use the new versions. My guess is that date will be March 1st, might be February 1st. I kind of doubt it. So between then and then, you can use either one of them. Okay? All right. So the first change we're looking at is really in paragraph 2C on accessories. Take a look at what they did here. Let's read through the whole thing. Accessories. The following describe related accessories, if any: window air conditioning units, stove, fireplace screens, curtains and rods, blinds, window shades, drapers and rods, door keys, mailbox keys, above ground pool, swimming pool equipment and maintenance accessories, artificial fireplace logs. All that stayed the same, but then they're adding security systems that are not fixtures. So if you've got the Ring doorbell that it's not really installed, it's hung there. Or you know how you got these security systems you just put on a desktop, they all stay. Unless you exclude them down here. So this is something when you take a listing, you're going to have to talk to it. We need to train all the agents in the office in this. Then they take a listing. They need to ask them, is that a security system on the table there? Yeah, we got that at Best Buy. It's great. Well, super. Understand that unless we exclude it here, this contract assumes it stays. Oh, no, we want to take it with them. Well, then let's make sure we exclude it. Then it goes on as it always has and controls for garage doors, entry gates, and other accessories. Then they've added a definition for controls. This includes the seller's transferable rights to the software and applications used to access and control improvements or accessories, and the hardware used solely to control improvements or accessories. If there's like a clicker for the drapes, that sort of thing. So that's not a huge change on that, but some minor tweaking that we needed to do. Then, do you know how in paragraph 4 of our current contract, We have to disclose if we do a transaction for ourselves, spouse, parent, child, business, anywhere we have a 10% interest or trust, right? They're moving that to paragraph 8. And here's what they're adding. Would y'all agree that we're doing more and more transactions these days on rental properties? People buying and selling rent homes. Well, we got to do a better job of addressing how that works and how we handle the leases. So what's been added, paragraph 4 is leases. And it starts off with saying, except as disclosed in this contract, seller is not aware of any leases affecting the property. After the effective date, seller may not, without buyer's written consent, create a new lease for obvious reasons, amend any existing lease, because that also would affect the buyer, or convey any interest in the property. Then it says, check all applicable boxes. And you choose one of 3 boxes, box A, B, or C. You can do 1, 2, or all 3. Residential leases, fixture leases, leases of natural resources. All right, residential leases. The property is subject to 1 or more residential leases to tenants, and the addendum regarding residential leases attached to this contract. So there's a new addendum dealing with residential leases. We'll look at it. Then future leases. Fixtures on the property are subject to 1 or more fixture leases. For example, solar panels, propane tanks, water softener, security system. And the addendum regarding fixture leases attached. So there's another new addendum we'll look at. Leases of natural resources. I don't think this is going to apply to us very much, but natural resources lease means an existing oil and gas, mineral, water, wind, and other natural resource or other natural resource lease affecting the property to which seller is a party. You check box 1, sellers delivered these to the buyer already, or they haven't delivered it. They're going to deliver it within 3 days, and then we're going to give the buyer X number of days to review that, and they don't like what they see, they can terminate. So that just sets it up for the 2 addenda that we'll look at in a minute. But folks, I got to tell you, the single biggest change, questions on that, by the way. The single biggest change they made is in paragraph 5. They're taking the earnest money paragraph and the option fee paragraph and combining them into a single paragraph. So it's now called earnest money and termination option. Let's look at the first half of it. All right, so delivery of earnest money and option fee. Within 3 days after the effective date, buyer must deliver to, XYZ title company, those great, whatever address, blank dollars is earnest money and blank dollars option fee. Check this out. The earnest money and option fee shall be made payable to escrow agent and may be paid separately or combined in a single payment. Hallelujah. No more running option fee checks around, worrying whether it gets there on time. Can we mail it or not mail it? If we mail it, is it delivered when you mail it or when it's postmarked and you deliver it? Who cares about all that crap? We just send it to the title company. They handle it from there. Now, when I first saw this proposal, my first thought was title companies are going to sit still for that. They did, and I'll tell you why in a minute. So I think that's wonderful. And they can make 1 check or 2 checks. It doesn't make any difference. Then subparagraph 1 is already in the contract about additional earnest money. We don't use additional earnest money a lot, but from time to time it can be useful. And it says, buyer shall deliver additional earnest money of blank dollars to escrow agent within blank days to affect this contract. Then you know how in our current contract with the earnest money, you got 3 days to get it there. And if that 3rd day falls on a Saturday, Sunday, or legal holiday, it rolls it over to the next day that's not a Saturday, Sunday, or legal holiday, right? But it doesn't work that way with the option fee. You got 3 days to deliver it, but it doesn't matter what that 3rd day falls. It could fall on Christmas. Doesn't make any difference. You would have to count that day. Well, that's inconsistent. So now they're going to handle them both the same way. I think this is another great improvement. 2, if the last day to deliver the earnest money, option fee or the additional earnest money falls on a Saturday, Sunday, or legal holiday, the time to deliver the earnest money, option fee or the additional earnest money is applicable is extended at the end of the next day. That's not a Saturday, Sunday, or legal holiday. So that's great. We're going to be consistent with that. So I think that's wonderful. Now, this is an important point. Item number 3 here says the amount escrow agent receives under this paragraph shall be applied first to the option fee, then to the earnest money, and then to additional earnest money. So let's be careful. The parties agree to $5,000 in earnest money, $100 option fee. Now they can write 1 check or 2 checks. It doesn't make any difference. But let's say they write 1 check and they write it for just $5,000. When that hits the title company is going to take $100 out of that to pay the option fee first. They're then going to apply the other $4,900 to the earnest money, and now the buyer is short on earnest money, which means the seller can walk away, sell to someone else, sue, whatever the case may be. So when we represent buyers, we need to make sure that they write a check or checks for the full amount of both the earnest money and the option fee. Also, 4, they're just cutting off what they knew was going to be a problem. It says buyer authorizes escrow agent to release and deliver the option fee to seller at any time without further notice to or consent from buyer, and releases our escrow agent from liability for delivery of the option fee. You know what's going to happen? They write the check today. Tomorrow they change their mind. They don't want to buy it, and they don't want to lose that option money, right? So they'll start making noises like, well, I actually never authorized them to release that to the seller. Yeah, you did. It's right here. It's already done, kind of thing. Now, here's why the title companies did not balk at all this. Because with one little exception, there's really no extra work for them because of this little sentence here. The option fee will be credited to the sales price at closing. So what's going to happen is they're just going to write the check or checks. It goes to the title company. They'll just hang on to it and credit the sales price at closing. No fuss, no muss. I guess if some seller calls a title company, well, I want that option money sent to me, well, then they'll cut them a check, but I don't think that's going to happen most of the time. So it'll just sit there at the title company, just like the earnest money does, and it gets credited to sales price at closing. So that is going to work nice. So the only really additional work for the title company on this is if a buyer terminates, they'll have to send a check to the seller for that option fee, and that's not that big a deal for them. Then what was paragraph 23, they're moving to 5B, termination option. Now this starts off pretty much the same way. For nominal consideration, the receipt of which seller acknowledges and buyer's agreement to pay the option fee within the time required, seller grants buyer the unrestricted right to terminate this contract by giving notice of termination to seller within blank days after the effective date of this contract option period. So that's the same. Then it says, notices under this paragraph must be given by 5 p.m. Y'all do understand that this is the only thing in the contract that's 5 p.m., that everything else in our contract is midnight, right? When TREC did this, I tried to warn them, don't do that. Because the moment you do, everyone's going to think everything else is 5. And I get that a lot in class and on the street. Well, everything's 5 o'clock. No, this is the only thing's 5 o'clock. They added a year or so ago, parentheses, local time where the property is located. What was happening? Sellers having to move because of a job transfer. They've already moved. They're in London. Buyers in Bahrain. Now, the option period ends at 5 o'clock today, and the buyer and seller start getting into an argument. We're talking about 5 o'clock London time or Bahrain time? The answer is it's neither. There's a well-known legal concept, both domestically and internationally, called lex loci. It's a Latin phrase that means law of the land. That unless the parties agree otherwise in writing, it's the law of the land where the property is located. You know how from time to time you get these people who move here from other states, and they go, well, that's not how we do it in Michigan. You know, we don't care because the property's here. It's Texas law that applies. Well, unless they agree otherwise in writing on this, it's the time frame here that applies, not London or Bahrain. So that'll help with that by the date specified. Then it says, if buyer gives notice of termination within the time prescribed, 1, the option fee will not be refunded, and escrow agent shall release any option fee remaining with escrow agent to seller. So if they're still hold on to that, they're just going to send it to the seller, right? But then the earnest money is going to be refunded to the buyer. Notice there's no more, well, hang on, I'll get to that in a second. No, let's do it now. Notice there's no more boxes. It will or will not be credited to the sales price at closing. Okay, it's just assumed it's going to be credited to the sales price at closing. Then, C is failure to timely deliver earnest money. D is failure to timely deliver the option fee. Keep in mind, if the seller, forgive me, if the buyer, I misspoke, if the buyer fails to deliver either one, you still have a contract. That doesn't negate the contract. There are just different consequences for each. Failure to timely deliver the earnest money. If buyer fails to deliver the earnest money within the time required, seller may terminate this contract or exercise seller's remedies under paragraph 15 or both by providing notice to buyer, here's the key, which is in our contract currently, before buyer delivers the earnest money. If the earnest money was supposed to be there by midnight last night and it didn't get there, so this morning a race starts. If I'm the seller and I give you the buyer notice, I'm terminating or suing or taking some other action, well, then that's what happens. If, on the other hand, before I give you any kind of notification like that, you get that earnest money to the title company, then you win that race. I don't want to leave it to that, but okay. D, failure to timely deliver option fee. If no dollar amount is stated as the option fee, or if buyer fails to deliver the option fee within the time required, buyer shall not have the unrestricted right to terminate this contract under this paragraph 5. So you still got a contract they have to abide, they just can't terminate. Then E, Time is the essence of this paragraph, and strict compliance for time frame performance is required. So this is the one and only paragraph where time is of the essence. Nowhere else in the contract. There are a few TREC addenda that have time of the essence, but not here. So when we say 5 o'clock up here, okay, if you represent that buyer, if buyer's going to terminate, you need to send me that termination before 5 o'clock, not at 5 o'clock, not 10 seconds after 5 o'clock, but before 5 o'clock. Now, I don't know about you. I think this new paragraph 5 is super. I love the fact we don't have to worry about running checks around. They just give the title company. They handle it from there. Questions on any of that? Other changes they made. Paragraph 8, what was paragraph 8, which is what was down here in B, broker's fees. All obligations of the parties for payment of broker's fees are contained in separate written agreements, because that stays. So what was paragraph 4, where you disclose you're doing a transaction for yourself, spouse, parent, child, etc.? They just moved into 8A. So they renamed paragraph 8, brokers and sales agents. A is what used to be paragraph 4. B is what's always been in 8. Paragraph 10. In 10B, we've had this thing on leases. All of this in red, they moved on to the addendum we're going to look at. So the only part of that they left is this. After the effective date, seller may not convey any interest in the property without buyer's written consent. Fine. But now they've added C smart device, because we're doing with more and more smart homes and more smart devices. And there's something here that cracks me up just a little bit. It says smart devices. Smart device means a device that connects to the internet. I don't think something's smart just because it connects to the internet. I know a lot of people who connect to the internet, would not characterize them as smart. Bad teacher kind of thing, right? All right, so smart device means a device that connects to the internet to enable remote use, monitoring, and management of 1, the property, 2, items identified in a non-realty items addendum, or 3, items in a fixture lease assigned to buyer. At time seller delivers possession of the property to buyer, seller shall 1, deliver to the buyer written information containing all access codes, usernames, passwords, and applications buyer will need to access, operate, manage, control the smart device. What keeps happening is they're leaving those devices, but they're not leaving the instructions on how to operate them. So now they're going to be required to leave written instructions that give them all of that. And 2, terminate and remove all access and connections to any of those other improvements that they're going to take with them. We just had to do a better job of dealing with these smart devices they did with that. So that's good.
I have a question on this.
Yeah, go ahead, Amy.
So my house, everything runs off of my phone, which is the application on my phone. Can someone come in here with any of this terminology and be like, well, I don't have a smartphone. I'm coming in with a flip phone and I don't have access to that. Can I have your phone now?
No, it's not a promise to leave your phone. What you're going to do is give them the information they need to get the app so they can control it themselves. If they don't have a phone that can do that, tough cookies.
The tough cookies. Okay.
Yeah.
Just making sure.
Oh, you betcha. Yeah. Now you got to know someone's going to try to make the argument at some place at some time, but no, it's not going to happen. We've had some weird stuff though. There was a case out of Georgetown in the Austin area. Seller moved out. Buyer moved in. A couple of weeks later, buyers get what's in essence a thank you note from the seller saying, thanks for being such great buyers. We hope you're loving the home and the neighborhood as much as we do. And oh, by the way, we really love what you did with the living room. The seller still had access to the cameras in the house. Now that's just creepy, right? Yeah. So you have to make sure all that gets set back to factory settings, consciously uncouple from them. Paragraph 18, some minor tweaking there, not really worth looking at. Paragraph 21 on notices. Okay, so we've had a line for fax machines and for emails. All right, are any of y'all still using faxes? No. So what they did is they just made both lines email/fax. So that in essence gives you 2 lines for emails. That's good. Paragraph 22 in the list of addenda, they added the 2 new addenda we'll look at in a moment, the addendum regarding residential leases and the addendum regarding fixture leases. Page 9 of our contract form, the broker information, they made 2 changes. First, they've added 3 places to put team names. Okay, so that's good. Useful. And then at the bottom of that, there's always been that place where you put in the commission, which is what we have here in red. Listing broker has agreed to pay other broker blank of the total sales price and the listing broker fee is received. Escrow agent is authorized and directed to pay other broker and listing broker's fee at closing. We kept running across this dispute. We have a listing, we put 2% in. as a commission to other firms. Buyer agent brings a form and puts 3% in there. And they try to argue later, once the seller signed this contract, that was an agreement to change the commission to 3%. That doesn't fly for two reasons. First of all, this is on page 9. Seller signs on page 8. The contract between although it's a 10-page form, the contract between the buyer and seller ends on page 8. Does that make sense? So this is after where they sign. The other is Trex legal counsel has always said in the very beginning, this is not a commission agreement. This is simply a notation to the title company to let them know how much to cut a check to the firm. So they're going to reword it for clarity. They're going to call it disclosure, not agreement, disclosure. Pursuant to a previous separate agreement, such as an MLS offer of compensation or other agreement between brokers, listing brokers agree to pay other broker fee blank. This disclosure is for informational purposes and does not change the previous agreement between brokers to share, pay or share commission. So that's good. Now, hopefully clarify that. Then on page 10, we have the 4 receipts. The only one we've had to deal with is the first one on the option fee receipt. But since that's now going to go directly to the title company, we don't have to mess with paragraph 10 at all. So I love the changes they made. I think they're, especially what they did in paragraph 5 with combining the option fee and the earnest money. So questions on that? Then let's look at those 2 addenda. The first one, addendum regarding residential leases. As I said, we're doing more and more transactions on rental properties. We have to do a better job of transferring the leases and security deposits and all of that. So look at what they did with this form. Residential lease means any lease of the property to a tenant, including addendum, amendment, or moving condition form. Seller may not execute, this is the 3rd time they make this statement. Seller may not execute any new residential lease or amend any residential lease without buyer's written consent. Existing residential leases will have the following status at closing, and you choose either A or B. A, termination of residential leases. All residential leases must be terminated by closing. Seller shall deliver possession of the property in accordance with paragraph 10 of the contract with no tenant or other person in possession or having rights to occupy the property. But in bold print, there's a notice. This paragraph will not amend or terminate any existing lease. You understand that if you buy a property, you inherit a property, or given a property that has an existing lease on it, then you're still bound by that lease. You can't just kick the tenant out because the property changed hands, right? So it says consult an attorney, refer to the residential leases for rights to terminate before agreeing to this provision. So let's say we're agreeing to close in 90 days. The tenant's lease is up in 60 days. What this paragraph A is saying is we're going to make sure that that lease is terminated and that tenant is out before we get to closing in 90 days so that the buyer can move in. If the tenant's on a month-to-month, we're going to make sure that gets terminated and we get them out before closing. Now, if the tenant still has 8 months, we agree to close in 90 days, but the tenant still got 8 months. Well, that doesn't work and it defaults to B, assignment assumption of residential leases. Existing residential leases shall be assigned by seller and assumed by buyer closing. Also, if you're going to buy a rental property, you think maybe you want to review the leases, make sure you understand all the terms. Yeah, well, that's what we do with this sub 1. Deliver residential leases, check 1 box only. Box A, buyer's already received a copy of it. Box B, they haven't received a copy. Seller's going to provide it within 3 days, and then we're going to give the buyer this agreed number of days to just review and terminate. Let's pretend I'm buying a rent home. I've been told there's a tenant in there on a 1-year lease and there's 4 months remaining on the lease. And I'm okay with that 4 months. Waiting 4 months actually works really well for my schedule. Super, but I need to confirm it. And of course, I want to see the other terms of the lease. So we check this box 2, they get it to me. And that's when we learned it wasn't a 1-year lease, it's a 2-year lease. There's not 4 months remaining, there's 16 months remaining. Well, then I can terminate, get my earnest money back. The other thing we've got to deal with is security deposits. So 2, at closing, seller shall transfer security deposits as defined under section 92-102 property code, if any, to buyer. Then, and by the way, notice something here. There's a duty for the seller and a duty for the buyer. Again, at closing, seller is going to transfer the security deposits, if any, to the buyer. But then at closing, buyer shall deliver to the tenant, a signed statement acknowledging that the buyer has acquired the property and is responsible for the return of the security deposit and specifying the exact dollar amount of the security deposit. Here's what's happened over the years. I own a rent home. I'm selling it to you. You're another investor. And we close the transaction. Let's leave it fuzzy what may or may not have happened to any security deposit. Time goes on. The lease is now up. Tenants moving out and they come to you as the new owner for the security deposit. You go, oh, I don't have that. You gave that to that Lloyd Hampton guy. So now they got to come find me in Paris or Buenos Aires, wherever it is I end up. If they do manage to track me down, oh, I don't have it. I give that to the new owner, and the tenant gets caught in the middle. So here's how Texas law handles that. Texas law doesn't give a flip. Texas law holds the buyer responsible the moment the buyer holds title. Whether they've received that money or not is immaterial. The moment they hold title, they are responsible. It's an issue between the buyer and seller, which agree the tenant should not get caught in the middle. Now, courts also hold sellers liable until such time as they can prove they transferred it, but ultimately that buyer's liable the moment they hold title. In commercial leasing, you're going to buy a shopping center, strip center. You want to make sure that all the leases are in effect, everybody's current on their lease and everything else. And we normally do that in commercial with what's called an estoppel letter, an estoppel certificate. And we don't really use those in residential, but this subparagraph 3 is getting pretty close. Except as described below, and to seller's knowledge for each residential lease, A, the residential lease is in full force and effect. B, no tenants in default or in violation of the residential lease. C, no tenant has prepaid any rent, because if they prepaid any rent, we need to prorate that as well. D, no tenants entitled to any offset against rent. E, there are no outstanding tenant claims against seller involving the property. F, there are no pending disputes with any tenant or prior tenant. G, there are no other agreements, options, or rights outside the lease between landlord and tenant regarding the property. Except for this, explain if any of the above is not accurate, attach additional sheets if necessary. All right, so that's fine. However, there's a follow-up. 4, seller will promptly notify buyer if seller learns any statement in paragraph B3 becomes untrue after the effective date. So you and I signed this contract on the 28th of October. When we signed that, all of this was true. The lease was full in effect. Nobody was in default. But now here we are in November, and the tenant has not paid their rent for November yet. Now they're in default. So 3B is no longer true. So under this paragraph 4, I have to inform you, the buyer, of that. I'm given 7 days to get it cured. And if I can't, you got 5 days after that 7-day period to terminate and get your earnest money back. Like I said, we just had to deal with these leases and security deposits and the like better than we have in the past. Questions on any of that? So one other form they passed last week, addendum regarding fixture leases. All right, this one's a shorter one.
Excuse me, Lloyd.
Yeah, go ahead.
So during this whole process, there is no form that acknowledging the tenant that this is happening.
No, you don't need that. That doesn't.
Okay.
I won't say it doesn't affect the tenant, but it's not the tenant's business. If I want to sell my rent property to you, I can do that. And tenant's got nothing to say about it.
Okay.
Because you're bound by the lease.
Okay.
Yeah. The only thing we're doing is notifying you that the security deposit's been changed or switched over. Yeah. All right. So in this fixture leases, it says fixture leases are those fixtures enter on the property that seller leases and does not own. Specifically, solar panels, propane tanks, water softener security system, other. Collectively, the lease fixtures. All rights to the lease fixtures are governed by fixture leases. Then 1, buyer shall assume and seller shall assign to buyer the fixture leases at closing, except the following blank. There are some of them, maybe they won't let the whoever owns the equipment won't let you assign it. Buyer shall pay the first blank dollars of any cost necessary to assume or receive an assignment of the fixture leases, and seller shall pay the remainder. Buyer and seller agree to sign any documents required by the lessor in the fixture leases to assume or assign the fixture leases. Also, 2, prior to closing, seller either will or will not remove lease fixtures covered by the fixture leases that buyer does not assume. Seller will repair any damage to the property caused by any removal. Notice, any lease fixture remaining in the property are subject to the rights of the lessor who originally owned it under the fixture lease. Then, delivery of the fixture leases. All right, so either 1, the buyer's received a copy of them all, or 2, the buyer hasn't received it. Seller's going to provide them within 5 days, and we're going to give them 7 days to review it and terminate. They also make it clear that at closing, there will be no liens or other security interests in these lease fixtures that aren't going to be paid at closing or that the buyer's assumed or has agreed to assume. But there's a notice right at the end that's important. Seller and buyer should consult with the lessor and their attorneys regarding the assignment, assumption, or termination of any lease fixtures. Let's say I'm selling you my house. I don't own the security system. That's owned by ADT. What this last notice is saying is you and I are going to get together with ADT to figure out what's going on. Does the buyer simply start making the payments under the normal lease and assume that lease? Or do they have to sign a new lease? Or will ADD come take their equipment out? Exactly what happens when we're transferring. These are the issues we're having to deal with more and more these days. We just had to do a better job of addressing them. So those are the changes that TREC put into place last week. It'll probably, my guess, it's going to be another week or 10 days before you actually start seeing the forms. For those of y'all, some of y'all who joined us late, the way it works is you'll be able to use these forms as soon as they're available. And then later TREC, and for now, you can use either the new forms or the old forms. TREC will later publish a date. My guess is March 1st, that after that date, you can only use the new forms. Questions on any of those? All right, now, if any of y'all are like managers, supervisors, team leaders, you got a licensed assistant, make sure you cover this and make sure they're prepared to be using these new forms. All right, now this is just supposed to be a broker issue thing, and it's really more up to y'all than anything else. So I kind of leave that to y'all. What I'm going to, I got a couple other topics I might get into. It depends. Do y'all have any specific questions or concerns that you want to bring up to me while we're all here together? Everything's just rosy. All right.
Yeah, well, I don't know if you want to address some of the issues with more recently that were announced yesterday by, I guess it was the National Association of Realtors, the 4 areas with the lawsuit. I don't know if you can address that or not.
Not at this point, because until the lawsuit goes further on down the road, we're not sure what it means.
Okay.
Yeah. Other questions? All right. Some of the problems I'm seeing as the compliance broker, okay, on that. Rebates to buyers, okay, or making contributions for them, this kind of thing. You do understand that it's fine to rebate some of your commission to the buyer under certain conditions. One is, if you don't represent that buyer, their customer, you're going to have the seller's permission. If to make a deal go, you're going to give $1,000 to that buyer because they keep driving out the landscaping, you're going to have to say, well, yeah, I'm going to do that, but let me check with my seller, make sure it's okay. I think that's common sense. The bigger problem we're having again and again and again is some of y'all are promising to give buyers back money, but you haven't run it by the lender. And at the end of the day, well, we're closing in 2 days and we're giving $8,000 back to the buyer on that. They're telling us we can't. What do we do? I said, you tell your poor buyer you can't do it. And then you stand the litigation when it comes up, and I ain't going to help you because you should have told them up front. Are we clear on this, ladies and gentlemen? You cannot promise these rebates until you've run it by and gotten the lender's permission in writing. It's supposed to be disclosed up front. It's got to be in the contract. It's got to be on the closing disclosure. And we keep having agents go, well, we're going to do it outside the closing, after closing. There's no such thing. It's considered to be mortgage fraud. Seriously, if they want to push it, you're talking up to 30 years in federal prison. You don't do it without the lender's permission. You're going to have to resign yourself to the fact that sometimes lenders are going to get permission, sometimes they're not. There's a lot of moving parts here. It depends on the type of loan. Depends on the LTV, the buyer's down payment. What other contributions we made? We tend to call it like seller contribution or an agent rebate. In law, it's referred to as IPC, independent party contributions. That's anybody kicking in this deal other than the buyer themselves. And there are limits on that total amount. Okay? It depends sometimes on the credit worthiness of the borrower. Above a certain credit score, they'll allow it, below it, they won't. It can come down to simply company policy for that lender. I came across a time when a lender told us no. And we asked them why, because it wasn't illegal in that particular circumstance. They go, we understand it's not illegal in this circumstance, but our investors are nervous right now. And they're finding that the less people put in of their own money, the more likely they are to default. So for right now, we're not doing it. The entire downstroke must come from buyer's pocket. So if you're going to start talking about this, the other thing is you got to have the broker's permission. You need to run this by Michelle, right? On that, because it affects the firm as well. So rebates are fine when they're done properly, but we have too many instances where agents are promising it without getting the proper authorization of the lender, and that's going to blow up big time. Questions on that? Go ahead, Leobel. Yep.
Okay.
There.
Could you hear me now?
Yep, gotcha.
Okay. And how about when we are helping a buyer with the fee, they're living in an apartment complex. So it's not closing cost. It's just that they have to pay a fee for terminating the contract before they should. And we're helping them with that.
Same thing. That's why in law it's called independent party contribution. It doesn't matter what the contribution is for. Closing costs, paying off a lease, whatever the case may be, doesn't matter. You're kicking in money for that buyer. It's going to go to that figure. So you still got to have it. I got 2 of those going on today, right? That agents have got me with. And I wish there was something I could do to help, but there's really not. You either get the lender's permission or you're going to have to go back and you're going to have to look that buyer in the eye and say, I'm sorry. I know I promised that. Turns out I can't do it. And there have been cases when firms have done that and then they've gotten sued and there's no way to win that one. Yeah. Other questions on that one? Then other issue I wanted to bring up. There is law now under the License Act and TREC rules that the very first time you do a transaction that you've never done before, you need to be supervised and mentored through that transaction. For example, if an agent, newly licensed agent joins the firm, the first time they do a single family home transaction, we simply can't let them loose on some poor unsuspecting sellers who don't know that this person never done a transaction before. So someone licensed and qualified within the firm needs to mentor them through that, whether it's a sales manager, one of the staff members, a team leader, something like that, right? Let's say that new agent then 6 months later wants to do their first condo transaction, which would you agree that's different than a single family home? We need to find someone to mentor you through that. An experienced agent joins the firm, but she's always done residential. Her best friend wants her to help her with a retail lease. They're going to open up a nail salon. We have to find somebody within the firm that can help them. And the bottom line is, if there's no one within the firm qualified to do that, then we can't let the agents do that one. So when you're getting ready to take a shot at a type of transaction you've never done before, land sales or something, get with Michelle, okay, and let her know, okay, I've never done this before. Who can we get to help me on this? Now, the other side of that is maybe we can find someone in the firm who'd be willing to help you, okay, just to be a nice person. Others will go, well, okay, what's in it for me? We have to figure out some kind of compensation for that. But that's now actually no longer a suggestion by TREC. It's now a matter of law. Also, let's talk a little bit about record keeping, and Lorraine does such a phenomenal job with that. They recently changed the law on what records we must keep, and they've added a couple of new items to that. We are now required to keep for at least 4 years all offers. Whether they ever came to fruition or not, we have to keep all. If there's ever an allegation, y'all never present the offer, we've got to be able to produce that offer. And if we can't, the assumption is we didn't present it in violation of law. Okay? And it doesn't matter how bad that offer is. It doesn't matter how screwed up it is, wrong form, wrong language, written on a napkin, scribbled with a stick on a clay tablet in cuneiform, doesn't make any difference on that. If you're putting your listings up and you're getting all that dumb stuff from some of the investors, those are all offers. We got to keep all of that, right? At least 4 years. So I don't know. Is there a way to do that? You upload that into Command? I never had to deal with .loop. I don't have to deal with Command. So I know diddly about that, but there should be a way for you to upload all that into Command. Am I right? Excellent.
Yes.
The other thing we have to keep for at least 4 years are substantive communications with the parties. Letters, texts, emails. Now, I don't mean every little text or email, what time to the closing, or you have so-and-so's phone number. But when you start discussing the possible terms of a contract, those are important written communications on behalf of your client. We need to keep those for 4 years. Now, emails, that's pretty easy. Texts can be a little challenging to keep, right? But there are apps for it. Go into your app store, Google store, whatever, and do a search for text to PC, and there are apps that will take your text, convert them, and send them to your PC, but we need to keep those. The only other issue that I wanted to bring up is our relationship with builders. We keep running across these situations where you take a buyer out, show them a builder, or maybe without you on a Sunday, they go out there and they do it or something like that. And we keep getting cheated out of commissions. what'll happen is the salesperson say, well, you know, if you cut your agent out of that, we can give you a washer and a dryer and do this kind of stuff. And they'll do that. When we go to the builder throws their hands up and go, that's got nothing to do with us. That's between you and your buyer. Now, we are supposedly covered under our buyer rep agreement. If you got them to sign a buyer rep agreement, right? In the buyer rep agreement we use, there's an agreement that we agree that the value of my services is, pick a number, 3% or whatever it is. And we're going to collect that from seller or seller's agent. But if seller or seller's agent does not pay that, Mr. Ms. Buyer, you're going to pay that or the difference, right? Okay. Well, sometimes that doesn't get emphasized quite as strongly as it should. They'll try to wiggle out. It's amazing how they just love you guys until they find a way to cut you out of the deal. And then for some reason you never did anything right. Okay. What I'm going to try to get us to do, I'm going to try to get Keith, our legal counsel for the firm, to draw up a separate addendum that maybe we're going to do with every buyer rep agreement, which is going to be a new home builder addendum. And it's going to really pound them hard that if you buy a house from a builder, that's fine, but we still represent you. We still get our commission, et cetera. Because it's just, y'all are getting cheated of commissions too often on that. And we can only make that decision to go to court over something like that if it's worth enough money. And, you know, $10,000, $20,000 is not normally worth enough to go to court. Okay. So that's something to think about. And just on the other hand of it, just make sure you emphasize that with your buyers as well. Let them know that if you want to, you know, if you're driving around one Sunday, go, oh, look at that new home, you go out there. Don't let the salespeople talk you into trying to cut us out on that, because we got the protection of the buyer rep agreement. So that's what I had on my mind as far as brokerage issues these days, the change in the contracts, handling those rebates and contributions, being supervised the first time you do a transaction you've never done before, record keeping all the offers, the emails and texts that are substantive, and our relationship with builders. So I'll just open the floor up to any questions y'all have. I'll stick around for a few minutes. Feel free to leave the meeting anytime if you got other things to do, but I'll stick around in case there's anything else y'all want to talk about or any questions you have. It's good to see three of you.
Good to see you too, Lloyd. Thank you.
Oh, you betcha. My
That's
pleasure.
great.
I'll be around if y'all need me.
Lloyd.
No, you betcha. Y'all have a great Thanksgiving.
You too. Y'all too, everybody.
All right.
Have a great Thanksgiving.
Happy Thanksgiving.
Thank you. Bye, guys. Like I said, I'll stick around for a few minutes if you need me.
Well, Lloyd, I know you're not a lawyer, but I'd be curious still to see what your reaction is to the news that you heard yesterday. Is there any kind of initial thoughts?
I have been in class for 5 days solid, so I haven't had a chance to look at it. Which one are we talking about?
Oh, the one where they just came out and made an announcement about how the, I guess, the branch of government that was trying to sue, I guess, the National Association of Realtors for disclosure and more disclosure. I think there are 4 areas that they looked at, but if you haven't looked at it, then
Who was suing?
was it Justice Department? I think it was trying to come after NAR. And
Hang on a second. Let me see. Do you know where you were seeing that?
yeah, that was Inman, I think, had news there.
Hang on. Latest real estate news. Oh, DOJ NAR lawsuit.
Yes.
Let me see. Let me read this real quick. These changes don't spell the end of anything. They provide consumers with information, transparent, protecting your client's interests, codifying the best practice are all good things. And it doesn't give me any detail. Why doesn't it give me?
Yeah, it looked like it was addressing 4 areas, but
And of course, that's just opinion. Hang on, let me back this up. Big win for discount brokers, how low fee firms benefit. Oh, here we go. DOJ sues NAR, alleges illegal restraints. Okay. So Department of Justice sues NAR alleges illegal restraints on realtor competition. Proposed settlement would require the trade group to repeal or change several rules in the U.S. Department of Justice deems anti-competitive. Oh, okay. Now let's see if they, you know, it gives me the headline. It doesn't give me any more detail than that.
Oh, okay. There was one that actually outlined 4 areas. One was just, for example, not being able to say that as a buyer's broker that you didn't have a real fee. Another was just opening up MLS to other sources. There were like 4 areas that the initial announcement.
If you can,
identified.
if you got like an article or something on that, could you copy that and send it to me?
Yeah, I'll do that.
I appreciate that.
Yeah, it just was out of Inman, but yeah, it just was the very first one that they broke.
The first one you said that if you buy a broker, you can't say that you don't work for a fee.
Yeah, so basically you say, if you're going to take and work with me, that's covered by the seller. Basically, he's agreeing, the seller's broker's agreeing to split the commission with me to bring a qualified buyer to the table.
See, I don't have a problem with that. It's kind of like you can say, well, if you work with me, it's free to you because the seller pays for it, but I am getting paid a fee. I'm just getting paid through the seller. So I don't see that as a big problem.
Yeah.
Now open the MLS. We've already opened the MLS up. You don't have to be a member of the MLS to do MLS anymore.
Okay. Okay.
But that may be just locally. It may not be that way nationwide. But yes, anything you can find, send me on it. But no, I've been solid in class for 5 days, so I haven't I've missed that.
Sure. Well, good to see you again, and happy
You too.
Thanksgiving to you. Hope you're doing well. Hope your knees are doing well. Are they doing? Yeah, I know you had an operation a while back. Is that all right with you?
Yeah, it's been a little over a year now on that, and yeah, it's like it was never injured.
Wow! Congratulations. That's great.
Yeah. Now the only thing I got to do now is get my eyes operated on so I can see again.
Oh.
Cataracts,
Oh, just yeah.
Yeah, getting old. All right,
That's
man.
Okay. That's
See you
all right.
later.
Got you. All right. Blessings to you, man.
You too. Bye.